Happy New Year. It is January 3rd, 2025. Happy New Year, Deanna.
Happy New Year to you, Steve.
Yeah, feels a bit weird to say that in the episode since we've been chatting for a few minutes already.
Yeah, yeah.
We are recording what should be a short episode today to follow up on our year-end review episode with Tamara. And in that episode, Tamara said that one of the things that she really hoped for in 2025 was that IRCC and CBSA could work out an issue with visitor records that emerged in 2024. I'm aware of a few judicial reviews that are underway on this topic. And if there are a few judicial reviews, there are likely many refusals. I think Tamara has said she's aware of an active dispute or something between IRCC and CBSA regarding how this is done, or at least confirming that what people had initially thought may have just been one or two officers having a very unique interpretation of immigration legislation with regards to visitor records is actually what the policy is. So I'm just going to take maybe 3 minutes to explain the issue. When a family applies to come to Canada as temporary residents, it is common that the parents will get work permits and the children will either get visitor records or study permits. A visitor record is essentially a piece of paper that someone gets when they enter Canada that lets them stay in Canada as visitors. People with visitor records in Canada are allowed to study if they are children. Typically, when the family arrives in Canada, the CBSA will issue the children visitor records that are valid until the expiry of their parents' work permits. So in other words, if a mother and father or two parents get a 3-year work permits, the children will be issued 3-year visitor records. The issue, so up until 2024, people on visitor records, when families would travel in and out of Canada, there was generally this understanding that the parents, when they re-entered Canada, could continue to work until the expiry of their work permits, and that the children could remain in Canada until the expiry of their visitor records. Under Canadian immigration law, there's specific terms for when someone's ability to work in Canada ends. And so it's clear in the law that even if someone exits Canada and re-enters, if they have a work permit, they can continue to work to the expiry of the work permit. The issue that has arisen is that the law does not, like Canadian immigration law, does not actually contain the term visitor record. And diving into the regulations, which I guess for those watching on YouTube, we can pull up, and I'm just quickly sending it to Deanna now. Section 183, sub 3 of Canadian immigration legislation provides that, or sorry, some section 183 sub 2 provides that when someone enters Canada as a visitor, they are allowed to stay in Canada for either 6 months or until the earliest of certain other provisions, which are in subsection 4. So subsection 4, 183, subsection 4, and I know this is getting a little bit legalese, but bear with me, provides that it is either 6 months or the earlier of A, the day on which the person leaves Canada without obtaining prior authorization to re-enter Canada, B, the day on which their permit becomes invalid, and then there's a bunch of other provisions that don't really apply at all regarding declarations that someone's, status is expired or the expiry of biometrics. The issue then with visitor records becomes, let's say if somebody comes in on a visitor record and it is valid for 3 years, and they leave after 1 year, they go to the States, say, and come back 1 month later, what when they come back in, are they allowed to stay until the expiry of that document that was issued for 3 years? Or did the fact that they leave Canada void the visitor record and now they only have 6 months? Up until last year, the interpretation was always, well, people can stay until the expiry of their document. What started happening in 2024 was that Immigration, Refugees, and Citizenship Canada started refusing applications where people had come back into Canada, and after the 3 years, they were either applying for permanent residence or they were trying to extend their visitor records. And there were scenarios of whole families up trying to extend documents where the parents were trying to extend their work permits, the children were trying to extend their visitor records. The parents were approved because there was never a question as to whether their documents had expired. The children, however, in several cases, were receiving refusals. And the refusal letter stated, and I'm just going to read from one that was sent to me. I should note neither Deanna or I, well, you haven't had any cases involved. I have actually hadn't had any refusals involving this either. I've just been contacted by numerous lawyers who were asking for input on judicial review and stuff. But anyway, the refusal said, quote, this is again for the children, not for the parents. The parents were approved. Immigration legislation requires that foreign nationals wishing to remain longer in Canada must submit an application for extension of their temporary resident status on or before the expiry of the authorized period. According to our records, you last entered Canada on X date. Therefore, the visitor record that was issued before with a later expiry date is no longer valid. Your temporary resident status expired 6 months after you entered Canada, and your application to extend your status in Canada was made after that date. And again, this is directed to the child. You are a person in Canada without legal status, and as such are required to leave Canada immediately. If you do not leave Canada voluntarily, enforcement action may be taken against you. Now, what Tamara had said in the year-end episode is that from what she understood, IRCC's position appears to be that CBSA, when people re-enter, should be writing in the passports that they are granting an extension until the expiry of the visitor record, and CBSA is not doing so. And so from what I understand, IRCC is saying this is a CBSA problem. CBSA, when people enter on visitor records, is telling people, no, no, you're allowed to stay until the expiry of the visitor record. So this is just, two departments not working well together. And it is children, for the most part, who are paying the price because, as you saw from the letter, they are getting this refusals where the parents are approved and the children are being told that they need to leave. That's sort of the issue.
Hmm.
I don't know, Deanna, what are your thoughts?
So I have not had a specific case like this. I've had a number of cases that are kind of adjacent to this. And this is also not a new issue in the sense that this is an issue that we raised probably almost 10 years ago when I was on the CBA executive, because it was arising at that time as well. It's sort of one of these things that comes into popularity and then it dies down and then it get raised again. Because I remember that when I was a table officer, we raised this as an issue because it was happening with great frequency. And I remember we raised it at one of our meetings and we said, this was the issue exactly. And we had a meeting with the Canada Border Services Agency. We used to have meetings with all of the departments, sometimes separately, sometimes together. And this question was, so what does it mean when somebody comes back in on a visitor record? Are they being readmitted on that visitor record, or are they being admitted just based on the regular stamping policy? And so I remember at that time, and I would need to see if this policy is still on the book somewhere, but CBSA issued a stamping policy, which was that that they are supposed to stamp on every readmission, and that either they write down the date of the expiration of the visitor record to confirm that you're being readmitted for that same duration, or if they do nothing, or they put in just a regular stamp with no date, that you're being readmitted for a 6-month period, as is the general rule. But of course, we were trying to communicate at that time that this is something that is not being properly communicated to people, and that there's a disconnect between CBSA and IRCC. And, at that time, again, even still, they were saying, no, 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 this is clear. The stamping policy should make it clear. CBSA officers are being told that they really do need to stamp passports. Now, from that point forward, the amount of passport stamps rapidly declined rather than increasing. And now they're basically not ever happening. Very often people don't even meet an officer. Their passports don't go through any kind of stamping. And I don't remember the last time I was seeing entrance stamps with any frequency. So the problem has clearly become worse. And I just know that when I now try and do extensions, I always take a very conservative approach because I don't like the ambiguity that's created by this. And so based on those experiences I had back in the day, I always tell people to extend after 6 months. But it always is kind of created this thing where people are like, are you crazy? I have status on this visitor record. What are you talking about? And I've always felt overly lawyery. But even then, when people are putting in an extension application, they're being asked to provide proof of when their status expired, which they're never able to do, because it's one of those situations where, when is your status expiry? Prove the date of your entry, but they can't because there's no stamp. So again, it's one of these situations where people are being asked to provide proof of something that is already in the hands of the department, but not in the hands of the applicant. And so it's just another iteration of that. Like, when you're trying to do a PR card renewal and you have to provide proof of all of your entries, they have that information, you don't have the information, but it's still, if you can't prove it, then they can refuse you. So it's again just immigration is kind of hoarding this information. It's not really well shared, and the fact that litigation is arising around this is really unsettling. And I really just hope that the court will take a very purposive approach and saying that, putting the onus on applicants, that they're supposed to understand that this permit is not actually a permit, that
Hmm.
it's just too much sophistication for people to understand that they're not allowed to treat this thing that looks in every way like a permit is not a permit. It's just so misleading. And so I think it's going to lead to great confusion. And I just hope that the court is very definitive about deciding these early cases to shut down this type of refusal. It's
I also don't
silly.
see why IRCC wants the extra work of
I
visitor rec
don't
or
know.
visitor extensions. But I think you touched on a very important point there that I don't think that a lot of people may know, which is when you hand your passport over to CBSA and they stamp it, if they stamp it, because as you noted, sometimes they don't, which is leading to all sorts of problems where I've seen accusations from IRCC that it's primarily to Americans who enter at the land border, where I think stamping is becoming a rarity and they're accused of
Very,
being in Canada without status because they don't have a stamp, even though, as you note, the CBSA records do show that an entry was made. And why there's why IRCC officers can't seem to see that, I don't fully understand, or don't in some cases, if they can in most. But if the officer does stamp the passport, it's 6 months generally. There's this unique issue with the visitor records that we're talking about. But if you see the officer writing something down in the passport, it's very important to check that out because they can both lengthen, they basically can write whatever date they want.
totally.
So if you saw them stamp your passport and you thought, great, I've got 6 months, but the officer only wrote 1 month on it, then actually the person only has 1 month. And with the stroke of, it's very important to see what the officer did with the stroke of a pen. I'm
Mhm.
not aware of any cases. As I say this, I'm thinking, I wonder if there have been cases where people just wrote on their own, like a year or 2 years, and extended their own stay, and how that all gets recorded. I'm not advising that people do that, obviously, but
Yeah,
I'm
of
not aware
course.
actually what mechanism there is to prevent that.
Yeah, I don't know either because I don't know that any of that information is ever tracked. And like, I mean, again, I strongly deter anybody from doing that because I don't know what is recorded, but at the same time, it is a very haphazard system. And I think that more often than not, as you're saying, there's no stamp at all. And so there's no place to actually make that alteration in any event. And there would be huge consequences of making an alteration to the stamp as well that you need to run to to avoid at all costs. But it's a very badly run system in the sense that like people are supposed to understand. I mean, one of the problems that I've run into repeatedly is people look at their visitor visa and they assume that the expiration date on their
Hmm.
visa is the date that they actually have to leave. And so explaining that just because their visa expires in a year doesn't mean they're allowed to stay for a year, that they're only allowed to stay for the 6 months if nothing was done. But that if the stamp is applied and a date is written in, or if no date is written in, there are implications to all of those things. But now in the absolute absence, almost absolute absence of stamping, what conclusions can be done with respect to visitor records? It's a really challenging one. And I think a lot of people are you know, finding that this is complicated. And I think that the extensions are even more complicated because people just, did they keep a copy of their boarding pass?
Hmm.
Or if they drove across, like how do they approve? How do they prove that that's the day that they entered Canada? And they are asked to provide proof of their last entry if they're trying to get an extension. So,
Yeah. And some
um,
people may be saying, and this probably be my last comment on this, except maybe, prediction or hope on how this will go. Well, why
mm,
don't the children just get study permits? And there's two reasons. First, a visa exempt person who is applying, so people who do not need a visa and who are submitting families where the work permit applications are being submitted in person, study permits actually have to be submitted online. So for the parents who are eligible to submit the work permits in person, if their children are also visa exempt, they will be given visitor records at the port of entry, not study permits. The second reason why some people choose to do visitor records is because, and I don't know if British Columbia is unique in this or not, but if you're a child studying on a study permit, you have to pay $75 a month to medical services premiums. If you're on a visitor record, you don't, which is just a weird quirk in the provincial health insurance laws. So that's
I didn't even
why.
know that. Yeah,
Yeah, it's a very like, and it might be unique to British Columbia. Um, yeah. So the I don't know where the litigation will go.
yeah,
I certainly, but it's also one of those things where I don't really understand why IRCC would take the interpretation that requires more work from them with
yeah,
seemingly little benefit. Like, I cannot think of what the policy rationale would be to authorize the children in for shorter statuses than their parents.
yeah.
Yeah.
Yeah. I mean, the only possible explanation I can provide is that it's a cash grab because you'd need to do an extension every 6 months, essentially. But
Yeah,
then
I
what's
feel
the
like that
point of
assumes they
issuing
make
the,
money on applications. I'm
I
not
know, I
convinced
don't
the
think that they
department
do
makes money
either.
on application. The fees, I mean, the fees haven't gone up in forever.
Yeah, no,
So, in
it's
his
true.
example of how far behind the fees are, they just announced that they were revisiting. If someone is deported from Canada, they had to pay for as long as I've been practicing, so for at least 15 years, the cost when someone comes back, they have to repay the cost of removal. That cost was set at 1,500, and it fell so far behind what apparently it actually costs that they have announced that they are increasing it effective immediately, or no, effective in 2025 in a few months to 12,800. So similarly, the work permits or visitor records cost $100. Um, I don't get, I would be very surprised. And that hasn't gone up since I started practicing. And I'd be surprised if that reflects what it actually costs to
Yeah,
process a visitor record.
yeah, agreed. Yeah, I'm with you. I,
Yeah.
I I don't understand.
First issue of 2025 and what I feel like will be a year of interesting
Bizarre.
interpretations and unique interpretations
Yeah,
as
indeed.
they in the year of trying to reduce Canada's population. Which is this is one way to do it, right? If your children are here without status and your children are told to leave, the parents probably will say, well, we'd better go too. And I don't think that's
Yeah.
actually why it's being interpreted this way. I'm not clear, but a cynic could certainly view it that way.
Yeah, it might have that effect regardless, because to litigate something like this is not a small matter.
Oh,
Um,
yeah.
eh,
Like, I don't think very many, I mean, I don't think very many, it gets to that thing where, again, some people may choose to have for extended periods children go back to a home country to visit grandparents or something while this is all sorted out. A substantial number of people, especially like highly skilled people and people who have options as to where they want to live, are going to say, screw this. And then down
yeah.
the road there, I mean, I'm not, um, and especially if there are permanent residence refusals because children are out of status due to a technicality like this,
Mhm.
it's just a very weird approach that's being taken. And if it is the case that CBSA and IRCC are behind the scenes
I
talking or
think
arguing
also,
about this, then it's unfortunate that it's falling on children.
yeah, I think also that we're sort of tracking at this stage the climate in Canada toward immigrants, the experience of being immigration practitioners, and the experience of being newcomers to Canada. And I think what we're commenting on here is that, like, for us as practitioners, it's very challenging to have to give this type of information to our clients. Like, okay, well, here's the problem. We can litigate it. We think that we would probably be able to get to a positive result, but it's probably going to cost you, $5,000 to $10,000. If we go all the way to a hearing, it's probably going to take a year. In the meantime, you're going to be living in this state of insecurity. Um, for the person that's here, they're going to be left with a very bad impression of Canada, that we've put them in the
Hmm.
state of limbo, like their experience of stress, not knowing their kids won't be covered by medical services, like just this. And again, I'm not sure what we're trying to accomplish by this. And so again, I mean, we talked a little bit about, before we got on, about this thing of you know, um, humanitarian and compassionate decision making, and it's sort of like what would shock the conscience of Canadians. And I think that what I'm seeing here is this disconnect. Would a Canadian think that this was fair, or would they still, like, it's hard to map what would shock the conscience of a Canadian right now, because that seems to be a shifting paradigm. Like, what would be like, oh, that's so
Yeah, I
unfair,
don't know.
versus like, I don't know, my rent is so expensive right now. My groceries are so expensive. I think that there is so much fear, acrimony, going out, like just ambient in our environment right now. What seems to be deserving of compassion toward newcomers is different than what it was 5 years ago. And so it's one of these ways that we can sort of track how 2025 is feeling different from what we would have thought of as being a Canadian value, let's say,
I
five
mean, I
years
used to
ago.
say that if Canadian citizens were treated by IRCC en masse the way that immigrants are treated, that
Yeah.
there would be a revolt. But then the passport, I remember when like passports were all messed up a couple years ago, and for the most part, people just said, okay. So I've given up trying to predict sort of what will shock and certainly motivate, uh, shock the conscience of Canadians.
Yeah. Yeah. It's a really hard time, I think, to evaluate that for sure. I think, you know, I think that in particular, I think it's pretty hard to shock people right now. I think it's been a tough few years.
Yeah, yeah.
Yeah.
All right.
All
The
right. That's
first
it
of
for
what
today.
will be, I think, a very, very lots to talk about this year.
That's for sure. Okay.